Did you know 90% of Mozambique's timber exports are destined for China? This is over 500 million cubic meters a year, yet almost half of the country's timber exports are illegal, depriving the government and local communities of critical revenue estimated at $146 million and $20 million in the period 2007 to 2013 respectively. This is according to the 4th International Learning Event of the China-Africa Forest Governance Platform. What do you think? With increased China-Africa trade and investments, what are the environmental costs associated with this? And does Africa have strong institutions to deal with the environmental burden? The Zimbabwe Environmental Law Association, ZELA, in conjunction with the Africa Institute for Environmental Law, brings to you the Political Economy Dialogues on Natural Resource Governance, PEDNAG. This is an ongoing series to raise awareness and advocate for the rights of communities and conservation of the environment and natural resources. Get ready to learn more about climate change, energy consumption, local service delivery governance, responsible investments, and so much more. Thank you for tuning in to today's episode.
Welcome to this very important PED series of PEDNAC, whereby today's series is focused on Chinese investments and legal jurisprudence in environmental law. What I find very interesting is the balanced discussion about Chinese investments in the sense of really getting to understand, because what is mainly in the public domain has been more of critiquing Chinese investments, not from a very objective point of view. And as such, I think this series based on evidence-based research really helps us in terms of really drawing a nuanced understanding in terms of how Chinese-based investments are being done in Africa. And today with us, we are having two very important experts with regards to research on legal jurisprudence in environmental law based on Chinese investments to help us really unpack this very important discussion. We have Josephine Chiname from the Zimbabwe Environmental Law Association and Professor Matthew Iri, who are also going to be, both of them are going to be sharing with us very important research that they've done to help us really understand this discourse. So without wasting much time, may I call upon Josephine, who's a legal practitioner or a lawyer by profession, who has done extensive research with a focus on so many things related to business and human rights, to take the floor. Josephine, if we can allow you to make your presentation within 15 to 20 minutes, and that we would then open the discussion or the floor for questions from participants, and we then have or hand over the discussion or the presentation to Professor Iri at some stage. So over to you, Josephine, to take us through.
Okay, good afternoon, good morning, depending on where you are joining us from. Thank you, Veronica, for this platform. So in my presentation, I'm not really going to draw much into the legalities like the acts and the cases. I'll try and give some of the aspects that we saw on the ground when we were doing our research on China-Zimbabwe relations, particularly looking at the environmental impacts that Chinese investments are imposing on Zimbabwe. So firstly, I would like to mention that the issue here is not for us to profile Chinese investments alone, but the issue of their environmental impact came into play given a huge footprint that Chinese investments are leaving in Zimbabwe's mining sector. And in the research that we did as ZELA, we focused mainly on diamond, gold, and chrome mining areas. So it does not necessarily cover all the areas in Zimbabwe. And some of the research areas were Mutoko, Zvishavane, and Marange. Those were the main research areas and part of Mazowe. So my presentation will be mainly focused on those particular areas. And also, I would like to mention that when we did this research, we also looked at what is the responsibility that the Zimbabwean government has in as far as the issues to do with environmental protection and management is concerned, looking at Chinese investment. So in that research, we were able to establish that in terms of international law itself, Zimbabwe has a responsibility to ensure that it protects human rights of its citizens. And the issue of the right to a healthy environment in terms of our local laws is part of the Bill of Rights. It's a human right. So we established that the Zimbabwean government has a duty to ensure that when they are operating Chinese investments in Zimbabwe has to respect the environment. And we also established that we also looked at what responsibilities does China has in terms of the investments that are happening in Zimbabwe. So in that particular aspect, we were guided by the fact that China is also part of the international human rights community, though at the moment there is no specific treaty or covenant that specifically deals maybe with the right to a healthy environment. The fact that China is part to the international covenant on economic, social, and cultural rights, which can be inferred to do with the issues to do with the environment, actually sets an obligation upon China, especially if you look at the General Comment 24, which was published by the UN Committee on Economic, Social, and Cultural Rights. It established that every country has to ensure that its conduct outside its borders or the conduct of companies outside its borders should actually respect human rights. So those were some of the things that we looked at. And also given that during its last universal periodic review at the UN level, China actually accepted some of the recommendations to respect human rights and to respect the environment in its conduct, in its overseas investments. It actually brought out that fact that China actually has that responsibility also to see that its companies operating in Zimbabwe respect human rights. So, and we also looked at what is the responsibility of Chinese investors or Chinese companies operating in Zimbabwe. And in that respect, we managed to look at the laws that we have in Zimbabwe. And in terms of our constitution, every person, be it the government, an individual, or even companies, every person operating in Zimbabwe has a responsibility to respect human rights. And in terms of Section 73 of the Constitution, the right to a healthy environment for citizens of Zimbabwe, or for Zimbabweans, is provided for. So given that aspect, we managed to establish that by the very fact that in order for Chinese companies to operate in Zimbabwe, they have to be domesticated, rather they have to be registered in Zimbabwe. By that very aspect, they are bound by the laws of Zimbabwe. And as such, they are supposed to follow the constitution, which says that obligation upon them. And we also looked at the various legislations that we have in Zimbabwe, particularly the Zimbabwe Investment Development Agency Act, popularly known as the ZIDA Act, which actually have a section which sets obligations upon investors in Zimbabwe, not just Chinese investors, but all investors in Zimbabwe. And one of the obligations that is clearly provided for is the obligation to respect the environment by investors operating in Zimbabwe, and also to respect the laws of Zimbabwe. So by that very section, Chinese investors are enjoined to respect the Constitution and also to respect the Environmental Management Act, which has provisions about how the environment is managed in Zimbabwe. So that's a general overview of some of the aspects that we looked at in the research. Now, looking at the direct impacts that the Chinese investments has on the environment. We looked at this aspect guided by the two aspects of the right to a healthy environment, looking at the procedural aspects as well as the substantive aspect. So what we were looking at was what is it that the operations of Chinese investments are bringing about on the environment. For instance, looking at the issues to do with air pollution, noise pollution, water pollution, and land degradation. How are Chinese investors in the areas that they're operating faring? And our research through focus group discussions, through key informant interviews, was able to establish that there is a huge footprint, or a huge burden that is being imposed upon the mining host communities through Chinese investments operations. For instance, in Marange, the focus group discussions that we had in Marange was able to establish that Anjin Investments, one of the Chinese-owned mining companies operating in Zimbabwe, before it stopped operations in 2016, it had contributed to the water pollution of Save Odzi rivers. And in this aspect, we managed to establish that though it was not only Anjin that was responsible, there were other local companies that were also responsible to the water pollution, but Anjin, it had a bigger operation in that particular area, and most communities attribute the pollution to Anjin. And also, we were informed that before Anjin stopped operations in 2016, it had dug pits on one of its concessions in Ward 30 in Marange. And according to the community members, some of these pits have a width of approximately 50 meters and 35 meters deep. Those are some of the statistics that we got from the focus group discussions. Unfortunately, we were not able to enter the concession and take pictures of some of these pits ourselves. And also, the main challenges that are really associated with this land degradation is the fact that children are falling into these pits, and also they are breeding grounds for waterborne diseases like malaria. And also the fact that this is the same story, rather, when we went to Zhishavane, we discovered that there are pits that are there. Some are new, like being caused by Chinese investments operations, but in some instances, the pits were already there, but the Chinese mining companies are operating on those same concessions, and they are digging deeper into the pits, and the same effects or impacts of the pits are the same across Marange and Zhishavane. Again, another aspect was to do with the issue of noise pollution. This was discovered in Zhishavane as well, where Chinese mining companies are mostly involved in chrome mining. And we were told by the participants in the focus group discussions and the key informant interviewees that most learners are being affected by the noise, especially when companies are doing their blasting and are doing are operating with heavy machinery. To really illustrate some of the extent to which the environmental impact is being caused in across Zimbabwe or in the mining sector by Chinese investors, there was a media report where Vindura Mayor on the 15th of November 2020 reported that they contracted Chinese-owned companies to do desiltation of Mazowe River. But apparently the companies that were contracted end up doing mining and are causing untoward degradation along the river bank, polluting the river, leaving pits, among other things. So these are some of the issues that we managed to find when we conducted our research. A deeper review or deeper revelation can be found in the handbook, which will be published in due course. Looking at some of the aspects, the procedural aspects of the right to a healthy environment and the impact of Chinese investments in the Zimbabwean mining sector, we looked at different aspects, and one of the main aspects that we looked at was the environmental impact assessment process. In terms of the laws, of Zimbabwe, those who are conducting mining are supposed, or those who intend to conduct mining, are supposed to carry out an environmental impact assessment process. And in this process, they are supposed to consult with those who might be affected by their activities. But through our research, we managed to establish that there are instances where Chinese-owned mining companies are starting operations before they have been granted an environmental impact assessment certificate by the Environmental Management Agency, EMA. And in this instance, because some of these activities occur in rural areas where some community members are not really vexed in the issues to do with the legalities and the laws surrounding the EIA process, sometimes these instances go unreported. An example that was given was in Rishavani, where a Chinese mine-owned company called China Zim International was stopped from mining by the communities and by the Environmental Management Agency after it had come to the attention of the communities that it was operating without an environmental impact assessment, and it was operating very close to a community irrigation area. And in other instances, we discovered that there is limited consultation of local communities. In most instances, the Chinese mine-owned companies and the consultancies that they hire to carry out the EIA process, they limit their consultation to traditional leaders or local leadership through the Rural District Council and the district development coordinators. And in some instances, the general local populace are not really consulted. This was the view of the community in Marange, that when Anjin did its EIA process in 2016, they were not consulted as communities. And when it came back, when it resumed operations in 2020, they were not really consulted. They were surprised to see the official opening on the national news, where the president was also presiding over their resumption of operations. Again, in Mutoko, we managed to establish that a mining company called Komborera Investments did not consult all the villagers that were going to be affected by their operations. For instance, their mining concession stretches over 2 villages, but when the consultations happened, they only consulted 1 village, leaving another village without having been consulted, though it's being affected by its operations. So in all this, we managed to establish that there seemed to be a disconnect between the institutions that grant mining licenses and the Environmental Management Agency, EMA, which grant EIA certificates. Though the Environmental Management Act through Section 97 established that the EIA certificate should be granted first before the granting of mining license. And this was also confirmed by our courts. The High Court has many cases that confirm this process. We find that in most cases, Chinese owned mining companies are obtaining mining licenses before they have gone through the EIA process and before they've been granted an environmental impact assessment certificate by EMA. So this is something that is really affecting the participation of communities in the process, as well as ensuring that communities are also able to monitor the environmental impacts, and based on the environmental management plan that the companies would have proposed. And again, the issue that really came out in the research, during the research process, was that there is very limited community participation and engagement between Chinese mine-owned companies and the local communities. And this is affecting the issues to do with the environmental management, monitoring, and also the company's social license to operate, because the communities feel excluded as the companies mainly deal or are perceived to mainly deal with the national government as opposed to the local host communities. Another aspect that came out from the research was when it comes to the issue of access to remedy, communities accessing remedy properly where Chinese mine-owned companies are involved in environmental degradation, is the issue to do with political patronage and corruption that is in the country. Communities feel that Chinese-owned mine companies or Chinese companies are what they called untouchables. You cannot hold them to account because they have the backing of some of other politicians who have the power to make the case go away. And this aspect was actually confirmed, or it's actually reported by the Parliamentary Portfolio Committee on Mines in its 2013 report in the chrome mining area, where it was established that the companies had an attitude of being untouchable and could operate above the law. The Chinese created the impression within the community and in some government institutions that they were protected by someone in very high office in government. Though the community could not verify who the person was, and when we did our research, we could not really verify who the high person is. It's something that the communities have. It's a perception that the communities have, and in most cases they end up not reporting violations because they feel that nothing will happen. And also the fact that most Chinese-owned mining companies operate in secrecy. There is limited information and limited accountability. Most of the environmental violations go unreported, and also no remedy is, communities are not able to access remedy. And another aspect that really came out was the nature of the operations, the way that Chinese investors are operating in other parts of Zimbabwe. For instance, in the chrome mining sector in Zhishavani, it came out that Chinese companies are not necessarily the holder of licenses. In some instances, they are partnering with local artisanal and small-scale miners. And in that partnership, there is really limited accountability on environmental protection, and communities sometimes they are not sure who should they hold responsible for the violation. Is it the Chinese mining company that is mining on a claim of an artisanal small-scale miner, or the artisanal small-scale miner? And in some instances, even the artisanal small-scale miner is not even the claim holder, but rather they have a tributary agreement with the original claim order. So that whole aspect and that whole secrecy is also affecting the issue of accountability when it comes to environmental management, environmental protection in the mining sector in Zimbabwe. So some of the recommendations that we came up with in the report, in the handbook rather, were that there seemed to be a need for the Zimbabwean government to really put an effort in creating strong institutions that operate above political power, operate above corruption. And this is the only way that they will be able to implement the laws that we currently have. In terms of the laws that protect the environment in Zimbabwe, we have the Constitution, we have the Environmental Management Act that have extensive provisions which if properly implemented, might be able to protect communities from environmental degradation and environmental harm. Again, the issue of interagency collaboration, the Ministry of Mines, Ministry of Environment, Environmental Management Agency seem to be operating in silos. So there is a need for collaboration. The government managed to do this when it comes to the grant of investment licenses through ZIDA. I think this can still be done when we are monitoring the mining sector throughout the mining value chain. So there's that need to ensure that there is interagency collaboration and cooperation. Again, the issue of transparency and accountability cannot be overemphasized because the Chinese mine-owned companies considered to be operating in secrecy. No one really knows who is operating where, and there seem to be a lot of secrecy around it. That fact actually gives the perpetrators a cloak to operate under, a cloak of impunity to operate under. No one can hold them accountable if they don't know who they are, where they are coming from, and how long will they be on that particular place. Again, another recommendation was for state-owned enterprises that are operating in the mining sector, in gold, chrome, and diamond sectors to lead by example when it comes to environmental protection and environmental management. And overall, we need a policy, a national policy on China-Zimbabwe relations. China is clear on what is strategy and what it needs from Zimbabwe, but it seems as if we are not clear what our goals, what is it that we want to achieve through our mutual relationship between with China. So there's a need to really clarify that. This will help all institutions when they are engaging and negotiating with Chinese investors. To the Chinese government, we recommended that through the embassy, it should actually monitor the conduct of Chinese-owned mining companies operating in Zimbabwe. We understand that China has a non-interference policy within the domestic affairs of other nations, and that's the policy that they are very keen on. That's the policy that they really want to pursue. But we are of the view that because of they cannot, negate this obligation to ensure that their companies at least are following the standards that they have set, because through our research, we established that there are guidelines, there are codes of conduct that Chinese investors operating abroad or overseas are supposed to follow through. And though some of those guidelines and code of conduct are voluntary, there is sort of a responsibility upon those who set those guidelines to ensure that those guidelines are being followed, at least are being followed. Also, like any other country which has a vast interest in overseas investments, we recommended that China should consider putting in place a mandatory human rights due diligence law. This is something that is being pursued in other countries which have vast outbound investments. So I think we thought that China should actually follow suit. And also we recommended that the China International Commercial Court should not just be honorary, rather it should actually be practical, functional, to allow victims of violations through the operations of Chinese mind-owned companies to access a remedy in the instance that they cannot do so in their home countries. And finally, for the Chinese investors, we recommended that they should, invest more in engagement with local communities so that they can actually build a relationship and a social license to operate. And that way they will be able to determine the areas in which they are affecting communities or they are lacking and find practical ways to remedy them. And in that respect, we recommended that they should at least put in place operational grievance redress mechanisms at the operational level to allow communities to interface with them and share their views and share their concerns with them. Also, given that we understood that Chinese mind-owned companies might be coming from a different jurisdiction where the laws might or may be different from ours, but it's high time that they invest in understanding our legal provisions and make an effort to respect the laws that we have in Zimbabwe. And for CSOs, we recommended that they should be watchdogs, continue to publicize research, provide evidence on the impact. And on impact, we are not necessarily targeting only the negative, but even the positive impact that Chinese investors are having in Zimbabwe, and also engage and assist with capacity strengthening of Chinese investors, government departments, and other relevant stakeholders, as well as create spaces that might allow for multi-stakeholder engagements between communities, Chinese-owned mining companies, and the government of Zimbabwe.
Thank you so much, Josephine, for that very elaborate and detailed presentation. This has really set the context in terms of really helping us to understand where we are as a nation in terms of the legal framework in relation to the conduct of business, particularly Chinese investments in the mining sector with regards to environmental rights and the broad spectrum of environmental law. Whilst I think in your presentation, you did allude that when it comes to the impacts of the mining sector globally, it has just not been a case that has been alluded to the Chinese investments, but to a lot of large-scale and even small-scale mining operations that have been rampant globally. And as such, the world has been faced with issues of legacy impacts emanating from business conduct related to the impacts on the environment. And what's important to allude to is that with the discourse on environmental law has actually evolved over the years, and what has really prompted the discourse on the formulation of laws related to the protection of the environment or fostering environmental rights has been the prevalence of some of these issues that Josephine you raised in your presentations, which really have raised a form of consciousness within states and globally on the importance of regulating the conduct of business operation with the view of protecting the environment. And as such, a lot of jurisprudence has been formulated where we're now seeing the world has evolved. We've seen a lot of countries having within their national legal frameworks through either constitutions and even environmental laws, entrenching some of these rights related to the environment and protecting the environment. And what I also liked about the presentation by you, Josephine, is that she also really helped us to understand if at all we do have substantive and procedural aspects that relate to environmental law and regulation related to business. And I think from your presentation, it is clear that we do quite have like a solid foundational framework which regards the importance of fostering environmental protection and environmental rights within the business discourse. But then I think the question that is always on the head of many citizens is where are we getting it wrong? We have the laws, we have the policy frameworks. And I think what is also very clear is the implementation, because what the law is providing on the ground is a total is totally different from what we are seeing on the ground. The issues of that EIA as well, which is a requirement for mining operations not to start without being done. They are not being done as followed. Issues of environmental management plans, that in terms of the monitoring of the environmental management plans, these are not being followed. And that's why we have cases of companies that are violating and not ensuring that they do put in place sound environmental management practices. What we are going to do at this point in time is we are still going to continue and give an opportunity to our second presenter, Professor Matthew Erie, to just take us through the presentation. So let me first of all introduce Professor Matthew Erie. I think I didn't do him justice when we started the meeting. He's an associate professor of modern Chinese studies in the Oriental Institute and associate research fellow of the Social Legal Studies Center at the University of Oxford. And he has done and produced a lot of researches related to on Chinese law, issues of property law, constitution, and so forth. And he has a research project that he's working on, the China Law and Development, which is being funded by the European Research Council. And as such, it is a pleasure for him to grace us during this series to share with us some of the work that he is, or some of this work that he has been doing related to China law and development, focusing on the legal and policy implications for Africa. A lot of us, we are always wondering, does China itself have the way that Chinese business operations conduct themselves in Africa? Is it how they conduct themselves in their countries, home countries? And I think this presentation really is going to help us to really understand if at all China has been moving with the times like many other countries in terms of providing the necessary legal instruments within their national frameworks, and even the conduct of their companies abroad, to help us understand how that has also evolved in that term. So at this point in time, may I ask Professor Erie to take the floor, and I will give him 15 to 20 minutes to take us through this presentation. So over to you, Professor.
That's wonderful. Thank you very much, Veronica. So I really want to thank the organizers for having me. It's really an honor and a privilege to be part of this discussion. Thank you very much. So what I'm going to do in my talk, it's really wonderful to follow Josephine, because Josephine has given a really excellent overview of sort of what's happening on the ground. My talk is going to be a little bit more macro perspective and probably more on the academic side of things. But I think the two talks are going to be complementary, and hopefully we'll have a nice discussion afterwards. So I'm going to begin by talking about my project, my research project, and then I'm going to go into a little bit of the details and applications for our specific topic today. So as was said in the introduction, I'm the principal investigator on a 5-year project called China Law and Development, funded by the European Research Council. And fundamentally, we're interested in this question of the relationship between law and economic development, and how China may be promoting certain conceptions of that relationship outside of China itself as it engages in more and more cross-border trade, investment, and aid, particularly in developing countries. So we're focused primarily on what the World Bank would call low-income countries, such as Ethiopia, but also moving up all the way to upper middle income countries like South Africa. What we're not focusing on is the kind of high-income countries, right? There's quite a bit of literature and discussion on sort of U.S.-China relations and Chinese companies investing in the U.S. We're not interested so much in that relationship. We're interested more in what China is doing in emerging economies. And what we really want to do is we want to engage with a broad number of stakeholders, including academics, think tanks, NGOs, law firms, both in the host states that are receiving Chinese capital investment and also in China itself. Because in China, there are many companies, law firms, scholars, government officials who are interested in these questions and problems, but there's oftentimes information gaps and asymmetries in communication. And so we're trying to provide a platform where more discussion can occur. And this event is a great example of that. So really, again, overjoyed to be here. So as I was talking about before, in terms of this divide between, say, China and the US and other developed countries, and China and developing countries, there's kind of a growing split or schism between how these two, broadly speaking, respective markets are perceiving the presence of Chinese companies operating in their jurisdiction. So this is a report done by the Brunswick Group called Understanding Global Opinions of Chinese Businesses, a Growing Divide Between Developed and Emerging Markets. They surveyed 9,700 individuals in 23 countries. And this is one of the results that they discovered, which is in developing or emerging economies, oftentimes there's a relatively higher trust in Chinese companies. So 80% in rising in that category, whereas in developed countries, it's about half of the respondents responded that they trust Chinese companies. So you can see this question of perception, right, which has been flagged already by Veronica and in previous discussions in terms of how people on the ground are perceiving Chinese companies. And what we have seen is that the COVID-19 pandemic has kind of exacerbated this split, right, where there's potentially growing trust or even reliance on China vis-a-vis so-called health diplomacy in developing countries, whereas in the so-called post-industrial West, there's even more distrust towards China and Chinese companies, right? What's interesting to note is that despite the massive negative impact that the COVID-19 pandemic has had on the global economy, nonetheless, some of the Chinese investment has actually increased during this time. So in the first half of the fiscal year of 2020, when COVID-19 is very much felt in terms of its negative economic impact, the Belt and Road Initiative non-financial overseas direct investment, so in technology, real estate, and commodities, grew by almost 20%. And it was strongest in the ASEAN countries in Southeast Asia, but nonetheless has been felt elsewhere, for example, in the Middle East. And also EPC, engineering, procurement, and construction contracts increased during this time as well. So this is all to say that this is very much a live picture, right? And even though COVID-19 has wrought significant damage, the Chinese outbound investment continues. Now, what are some of the concerns of Chinese companies as they invest in developing countries? Well, this is a table I generated from a number of surveys conducted by the China Institute of Corporate Legal Affairs, the 中国公司法务研究院, which was established in 2014. And basically what this institute does is to try to promote and enhance the role of corporate legal affairs and business practice in China amongst Chinese companies, right? So they surveyed Chinese companies that are involved in outbound investment, and this is what they found. And so what you can see is one of the major risks that Chinese companies perceive is quote unquote unstable legal systems in host states, or what's called incomplete legal systems of host states. This is the English translation from the original Chinese. What's interesting is as a response or as a reaction or consequence to the Chinese companies' difficulty in integrating into local legal systems, there are lawsuits, right? So in the first year, over 50% of the respondents were involved in some kind of civil litigation, which is significant, right? And almost 8% were involved in some kind of criminal suit. Again, pretty significant. And then in the following year, we see that number of criminal lawsuits almost double. And so the number overall of these commercial and to some degree criminal disputes have been prominent in a lot of the investments, right? So this is all presenting the Chinese companies with a series of significant challenges. So what we're asking is a series of questions. The first one is, how does China protect its overseas investments? Okay, so what we know is that China is not known for legal development assistance, right, as the US did, and to some extent Germany and the UK. China does not engage in transplanting its laws overseas. It also, as Josephine said, has a policy of non-intervention. So how does it create environments for transactional security, and how does it protect its investments and assets overseas, right? So that's the first question, which is kind of a descriptive question. The second question is an analytical question. So what is the role of law in China's global development? Whose law is used in these contracts? where, how, and according to whose law are disputes settled, right? Is it local courts, say, in Zimbabwe that are taking these disputes? Are there Chinese courts that are taking disputes? Is it international arbitration? Or is it totally extra-legal? Is it all happening outside of the formal law and through negotiation? And then thirdly, what are the effects of China's cross-border ordering? So this is sort of the normative question. Does the Chinese presence lead to a race to the top or a race to the bottom, potentially, in host states that are receiving Chinese capital? So moving from the pragmatic question of sort of investor protection and risk assessment, I wanted to just briefly touch on kind of the broader academic question, which is a kind of epistemological one. And that's just a fancy word that means how do we know what we know? And a lot of what we know about Chinese law and governance is through Anglo-American eyes. And these are just a number of very famous books that talk about how Westerners, the Brits, the Americans have perceived Chinese law. And over time, it's been largely a negative perception. And so Timo Raskola talks about legal Orientalism, right? That China has no law. So we're interested in shifting this kind of epistemological gaze, if you will, to ask, well, what does Chinese law, governance, and ordering look like through the eyes of, say, a Pakistani union worker, an Ethiopian laborer, or a Kenyan regulator? And so we work with a broad number of research associates who are positioned in various jurisdictions. Some are academics, some are lawyers, some are based in think tanks. And they're really throughout the world. We have Cambodia, Nigeria, Georgia, Sri Lanka, the UAE, and elsewhere, and to try to obtain new purchase on what's happening and to learn through their eyes what is happening on the ground and in cross-border transactions. Now, on this question of how does China create order across borders and how does it protect its investments? There are, broadly speaking, two kind of camps in the literature. This is sort of the literature review section. The first camp says, and this is mainly produced by scholars of international economic law and private international law, they would say that law plays a very important role in what's happening in terms of China's promotion of order overseas. So they would say as part of that, there's a deep pragmatism. So Chinese companies are very much interested in protecting their investments. It's not so much about ideology. It's not about promoting communism or Chinese socialism. There are ideas that are pushed around. For example, Xi Jinping talks about the community of common destiny, the Renlei Mingyun Gongtongti, which is a very kind of vague concept, which is an inclusive notion of development, talking about economic, social, innovation, technology, and so on. So maybe there's an ideological component, but really it's quite muted. These people in the law positive camp also say that the Chinese government and Chinese companies have a preference for soft law over hard law. So soft law would be, for example, MOUs, and MOUs are broad, they're a bit vacuous, they allow for room and maneuvering. Hard law, as we all know, is more difficult to maneuver under. It imposes obligations, right? Thirdly, we do see the integration of Chinese norms into existing international organizations. So, for example, in the field of data governance, which is a very hot area right now, the Chinese are promoting their industrial standards through the ICANN and through the ITU, these established organizations. And also in the UN, we see China promoting its notion of human rights through the UN Human Rights Council, right? So development as a human right. So the Chinese are using existing organizations to promote their ideas and their values. And also we see a preference for bilateralism over multilateral agreements. So China has more bilateral investment treaties than any other country in the world besides Germany. Okay, so there is the use of international law at that level. And also the Chinese are very much on the forefront of promoting their version of dispute resolution. So this is a huge topic. I can talk about it in the Q&A, but not only the China International Commercial Court, which is referenced at the outset, but also arbitration. And so the Chinese now are building out not only arbitration based in China, and it's Beijing, Shanghai, and Shenzhen, that the International Arbitration Commissions are trying to attract more cross-border disputes, but also building institutions in Africa. The China-Africa Joint Arbitration Center, for example, which is the first ever instance of the Chinese co-building a dispute resolution mechanism outside of the territorial jurisdiction of the PRC. Right, this is established in 2015 in Johannesburg, and there are branches in Nairobi and in the OHADA system as well. So this is a really interesting development. We'll see what happens there. So that's the one camp. Law matters. The other camp says no, law doesn't matter, and rather, when the Chinese are building order, it's all about informality. So it's not law; it's these informal relationships, oftentimes that take the form of diplomatic and bureaucratic relationships. And so problems are resolved through these means and not through legal measures. Again, policy over law. So, for example, people like former World Bank chief economist Justin E. Fu Lin would say that it's really all about policy in China, that law doesn't matter. Right. And then also this notion that it's really about public order as opposed to private ordering. So contracts may play a role, but really it's state intervention that really kind of orchestrates the party-to-party contracts. And then, of course, guanxi, this idea that Chinese have this special notion of social interconnections, which is distinct from that of other communities and societies, also is oftentimes bandied about in these sort of law negative conversations. What we want to do is kind of bring these together, okay? The law positive, law negative, and I forgot to mention that corruption is oftentimes added on along with guanxi, and the two are sometimes conflated. But we want to, in our study, look at both the law positive and law negative aspects. So it's important to look at law, but also think about issues and concerns and measures for ordering beyond formal law, because that seems to be an important aspect of what's happening. So CLD then is trying to create an analytical theory and framework to explain the nature and implication of Chinese ordering outside of China, particularly in emerging economies, to create environments for transactional security and also to further China's geostrategic interests. And then just briefly to kind of look at sort of how capital exporting economic superpowers have done this in the past. As I mentioned, the US had its own moment in law and development in the 1960s when it was exporting its own legal institutions, in particular sort of legal adversarialism, the court system, US legal education, pushing these outside of the US in Latin America, in Africa, and then in the 1990s during the rule of law revival, so-called, also in Asia, we see a very different approach that China is taking. So as opposed to promoting its notion of law in accordance with a specific ideology, we see China kind of building on private international law or transnational law and continuing to use existing institutions and organizations that the so-called West has developed, but also creating alternatives, and in addition, relying on extra-legal and non-legal norms, some of those law negative aspects that I talked about. But CLD, or China Law Development, is really focused on sort of China's interests, right? So protecting the economic and political interests of the Chinese state and the Chinese companies. It may potentially lead to avoiding local law through, for example, recourse to international arbitration, very limited institution building, very limited role of legal missionaries, although that plays a part. It's a very interesting question. Happy to talk about that. As I mentioned, we're interested in moving beyond this just purely legal orientalist notion that there is no such thing as law in China, because I think that notion has been disproven, it's outdated. And also looking at, in particular, the enhanced role of informal networks that we see between China and its partners in developing countries. And so what ultimately we are kind of identifying is a sort of continuum of norms from the formal to the informal, right? And so we're operating and building the analysis within this continuum. All right, so that's all kind of very academic and theoretical. What I want to do now is I want to shift to this question of China's environmental governance. And I want to begin with the domestic picture, because I think to understand how China may be promoting certain notions of environmental governance outside of China, we have to begin with how it has been doing so within China, right? So we need a frame of reference. And here are just three very famous books that talk about this question from different perspectives. So as we know, since the 1980s, China has embarked upon record-setting economic growth through urbanization, through infrastructural building and design, light and heavy industry. And this has caused a huge demand for natural resources, right? So water, land, and energy. This has also led to major polluting entities. So, for example, petrochemical plants, semiconductor factories, strip mining, which, by the way, some of which were invested in by Western multinational corporations, right? It's important to note that. And this in turn has led to massive negative externalities in the environment. So talking about water, air and soil pollution, deforestation, flooding, and species loss. In the 1980s, there was an expression in China, pollute first and control later, or 先污染后治理, right? And I think that notion was very much sort of operative during the 1980s and 1990s during this sort of economic takeoff, right? Now, what was the response? Beginning later in the really 90s and early 2000s, once the damage and loss to the environment was really felt, well, there's a number of measures. The first is formal law, and so the National People's Congress has issued a number of laws at the national level. The environmental protection law came out very early, but really it was kind of a dormant law. It wasn't until its 2015 amendment that it kind of really sort of took on a life of its own and had teeth, so to speak. But you can see here, I won't read them, but a number of laws that came out really kind of in the 2000s and some are quite recent. We also have the kind of revision or the ongoing evolution of various regulatory bodies. So the most important for our interest here is the Ministry of Ecology and Environment, formerly the Ministry of Environmental Protection, and before that, the State Environmental Protection Administration, which kind of nominally oversees a number of other ecological and environmental authorities, beginning at the county level and above. So China has a kind of a multi-tiered level of administration, and there's this sort of this nominal notion of oversight. And yet the MEE is really kind of a weak regulator. It's hampered by dependence on local officials and local governments. And so enforcement is very much an issue. As we know, China has a devolved system of governance. We tend to think about China as very centralized, and it can be, but also when we look at its everyday governance, the local governments have a huge amount of kind of discretion and sway in terms of how regulations are actually implemented and how laws are enforced. And so local governments are oftentimes incentivized to protect polluters, and so you have this problem, right? This disjunct kind of agent principle problem. There's also, in ABC sort of signifies the departments with administrative supervision, natural resource departments, and so on. So these have traditionally kind of in the early period of China's economic reform sort of suffered, but in the 2000s, we do see more funding going to these bodies, which has certainly been an improvement. And one dimension of this changing sphere is litigation, environmental litigation. And this is a slide taken from Rachel Stern's book. And we can see broadly that there are administrative lawsuits, so those lawsuits that are brought against primarily public bodies, governmental entities, and then civil litigation. There's also criminal litigation, although it's less used. And the vast majority of suits in China are civil litigation in nature. They're less administrative or criminal. In 2010, the Supreme People's Court counted 12,018 pollution compensation cases. Which this comes from Rachel Stern's book, which she, sort of has a caveat that we have to be somewhat skeptical of Chinese statistics. Nonetheless, it's a helpful data point. And this can be compared to 2005, when there were only 1,545 cases that were brought through the court system. So there's a real improvement here in terms of the courts taking on these cases. There was a study conducted by Zhongnan University, which showed that oftentimes cases are brought by workers and by peasants, those living in the countryside, and plaintiffs won at least some compensation in 43% of the cases. So there are some earnings, there are some successful plaintiffs that are coming out of the system. But besides litigation, okay, we can't emphasize too much formal litigation. There's also government brokered deals, there's private concessions, and there's also the unfortunate phenomenon when plaintiffs give up, right? And then so some disputes sort of end with that result. The plaintiffs just sort of capitulate. Now, one important aspect of the Chinese domestic story is civil society. China's earliest and most successful NGOs were environmental NGOs. This is one of those NGOs here, an image from their website. And they've operated in a certain space whereby the work that they did was complementary to that of the government. So they weren't adversarial towards the government, but they were actually kind of fulfilling functions that the local governments should have been doing. And that way, they were helpful to the central government in certain ways, okay? Oftentimes, they were assisted by foreign NGOs. There was foreign assistance. So this is sort of the early, sort of 90s, late 90s, and to some extent, early 2000s story. Unfortunately, since Xi Jinping has taken power in 2013, we have this crackdown on foreign NGOs. There was a foreign NGO law passed in 2017, and this has resulted in sort of the shrinking space of certainly of foreign NGOs in China, but also domestic NGOs to some extent. And this has potentially been to the detriment of some of these environmental causes. So that's by way of sort of understanding the domestic side. Now moving to the cross-border dimensions of what's happening. And in comparison to the rather robust system of governance domestically, what we see in terms of the cross-border governance, it's quite nascent. It's really very much embryonic and it's fragmented. So these are a number of the regulatory bodies that have some level of regulatory oversight over Chinese enterprises that are investing overseas. So the National Development Reform Commission, which has oversight for approving overseas investment, MOFCOM, the Ministry of Commerce, which has its own overseas investment management system, and a number of other entities which are involved in this process of providing approvals to Chinese companies. So SASAC for SOEs, China Development Bank, and the Exim Bank, of course, may issue specific guidelines as part of their credit provision. And then we talked about the MEE, right? Now, the problem with the MEE, and I'm currently doing research with the wonderful Professor Zhang Jingjing, who I know is a friend of Zella, and I think she's on this webinar, and looking at sort of the limitations that MEE has, right? So unfortunately, MEE cannot manage and regulate overseas investment matters as they pertain to the environment. So under the relevant law, Chinese companies don't have to conduct and submit environmental impact assessments for overseas investments. So there's a kind of limitation that the MEE has here. And so when you look at the power of the regulatory body that should have that regulatory oversight, in fact, doesn't have that power, okay? In its place, we see a number of soft law sources, codes of conduct, guidelines, and corporate social responsibility, which since the 2008 Sichuan earthquake has really taken off in China. There's been significant improvement. The corporate law was revised to include the concept of corporate social responsibility. The Shanghai and Shenzhen stock exchanges have issued guidelines for disclosing CSR performance, and the Hong Kong Stock Exchange also in 2016 made environmental social guidance reporting compulsory, right? So we can see more traction in corporate social responsibility among the SOEs, the state-owned enterprises, but really the quality of their reports are mixed. And this is particularly so when we look at the private companies where it's even more mixed in the quality. And I should also mention that many of the PRC laws and the regulations require that Chinese companies, when they're operating overseas, follow local host state law, okay? So, for example, the measures for administration of overseas investment issued by the Ministry of Commerce in 2014 states in Article 20, Chinese investors must abide by the laws and regulations of the investment destination, okay? So there's a kind of delegation, if you will, certainly a recognition of the importance of local law, and I think that's incredibly important, but also sort of the delegation of the oversight to the local bodies, all right? So what about these sources of law? This goes back to that distinction of soft law, hard law that I mentioned at the outset. Well, there's a number of these sort of sources of these normative documents. which are regulating Chinese outbound companies in terms of their environmental obligations. But oftentimes they are non-binding in nature, right? So the question really is, what work are they doing? And how can they hold Chinese companies accountable? So this is sort of very much an outstanding question, a question that really needs more attention, I think. Even where there is a legally binding measure, oftentimes it's very vaguely drafted. For example, we can see the measures regulating enterprises' overseas investments that encourages investing entities to pay attention to ecological and environmental protection, right, and establish a good image of Chinese investors. So, operating within that language, that Chinese companies could interpret that in various ways, and then the actual, liabilities imposed is equally vague in terms of recourse that people impacted may have. Now, what about the impact of Chinese companies operating overseas in terms of potential human rights concerns? Well, this is a report done by the Business and Human Rights Resource Center that came out this year. They looked at 679 human rights abuse allegations between 2013 and 2020 that were linked to Chinese business conduct overseas, identified by sector and by region. You can see Africa in blue here, and metal and mining is sort of the large one, right, in terms of the number of concerns that were flagged by people and by communities that were impacted. Now, what about potential sort of policy response? So these are just sort of very broad, very general recommendations in terms of building the local ecosystem of compliance. So ensuring that foreign investors, including the Chinese, but certainly not limited to the Chinese, right, that they comply with local law, because I think one base in a host state cannot depend upon the home state, the capital exporting state, to ensure compliance necessarily. It has to be done sort of within the legal and regulatory system in the receiving state. So, of course, these comments have to be preceded by the observation that any recommendation has to be tailored to the specific political, cultural, economic, and historical factors of that country. There is no one-size-fits-all solution here. You cannot cut and paste. So I just want to recognize that. But really, we're looking at sort of clear rules. So, for example, environmental impact assessment obligations, but also critically enforcement, right? And so when we talk about enforcement, there's that human resource dimension. The staff needs to be, well trained. They need to be professionally organized. They need to be well funded, right? So financial resources is extremely important. There needs to be independent and efficient courts to provide remedies to people affected. The courts cannot suffer from corruption. They cannot be overwhelmed in terms of a backlog, right? Such that people will think, well, it's no use. It'll take me 5 years to get anywhere with this suit, right? There has to be efficiency. There has to be independence and autonomy. But critically, I think there has to be checks and balances in what's happening, right? In the relationship between the investor and the host state. So civil society can play a supplementary role, can check the government through training, publications, community outreach, and strengthen legal institutions. And also free media can play a very important role in issue spotting and foster public discussion. So for example, when we look at the relative success of the standard gauge railway project in Kenya versus the ongoing difficulty of the Ethiopian Addis Ababa Djibouti railway that has suffered a number of sort of financial problems, one of the key distinctions in the relative success versus the not so successful story of the latter is the role of civil society and media in bringing various Chinese companies to account in terms of their obligations to local environmental and other concerns. And lastly, education. I mean, it seems very obvious, but I think it's worth mentioning that there has to be not just technical ongoing education for government officials and for lawyers on these issues, but also for the general population. There needs to be education programs and opportunities provided to them so that communities ultimately, and countries can learn from each other, because there certainly is a siloing effect in terms of how different host states, recipient states are engaging with China. And I think there should be much more learning across the jurisdictions, and everybody would benefit as a result of that. And then lastly, I just wanted to list out some of our publications, and I will end there. I'm very happy to answer any questions people will have. Thank you very much for your time.
Thank you so much, Professor Eri, for that very detailed and very comprehensive presentation. I think it was very, very insightful. We all had an opportunity to really get to understand how the China, the legal, the structuring of how Chinese investments are really being safeguarded through China law and development. And I think what's quite particularly profound is how getting insights from a very, very informed and evidence-based research to understand that, contrary to what the majority of people without any evidence might allude that, Chinese general investments have not instilled a lot of confidence within African states based on some of those perceptions. The reality on the ground is that, as you profiled, especially during this COVID-19 pandemic, there has been actually an increased uptake and investments of Chinese investments, and really also making and showing the importance of such a discussion that we're having, that China is really indeed becoming Africa's biggest trading partner, investing a lot of millions and billions of dollars, especially in the extractive sector. And the question I think that is very important to tackle is, whilst the much needed capital and investment is happening, we cannot also override some of those discontent or non-compliance issues that you profiled in your presentation related to issues of illegal and policy aspects related to issues of environmental rights, particularly in the mining sector. And what I also really, really appreciated from your presentation is the getting us to also really understand the sort of like the framework related to Chinese investments and safeguarding such investments, where we have a mixture of hard laws, which in your research you profile that some of the hard laws or underpinning environmental compliance, they are not very strong as we would expect, and also in line with international based models or practices related to environmental regulations, as well as also providing that largely they are more of like soft laws, which means they are non-binding and are really just persuasive. So the onus is mainly on host governments to ensure that they do create legal and sound legal frameworks related to ensuring that there's compliance of environmental management laws within some of these Chinese investments. So the questions that I would maybe flag to Josephine is that there are questions related to your presentation on EIAs and the limited consultation, and if at all there is any legal actions that have taken or being taken against such malpractices or non-compliance. And for Prof, maybe I would pose a question to you. As part of your recommendations, you profile the importance of having independent, efficient judicial systems and court processes. And my question to you is, in your study, do you think environmental legal jurisprudence is something that has somehow gained traction in terms of the African landscape within our courts, in terms of really understanding and also providing sound judgments related to this whole notion of the importance of ensuring that environmental rights that are provided, some of these laws and constitutions are actually fulfilled, and actually companies, especially Chinese investments, are held to account. So maybe we can give the floor to Josephine to answer some of those questions related to issues of community participation, whether it would owe there's justice. I think there was also a question whether the consultation that can be done or that is usually done for mining within the traditional leadership suffices to be effective and adequate consultation on behalf of the impacted communities, and if at all communities out there can take action towards some of these malpractices or failure to comply by law. So we can we can start with you, Josephine, and then we move to Prof with those two questions.
Okay, thank you, Veronica. When it comes to EIA compliance in terms of what actions, I think I'll start with the easier with the easier one. When it comes to what actions can communities take, or have communities been taking any action? I would like to say that many communities that we have worked with, like communities in Shishavane and some in Marange, have managed to take action where there is no EIA compliance by different mining companies, including Chinese investments. The example that I have given of China Zimbabwe International, it happened in Zhishavane, Mondogori area, and it was the communities who managed to alert Zela lawyers about the situation on the ground, and they were able to get administrative justice through EMA, because EMA, as an administrative body, has the power and legal authority to issue environmental protection orders. So if those are complied with, there will be nothing further that communities can do, because whatever violation would be remedied, and that is what happened in that instance. And in terms of consultation, the Act itself say, and the regulations, the Act and the regulations that deal with EIA read together stipulate that concerned those who will be affected by a particular project. And there is no particular or definition of what do we mean by those affected. And at the same time, Section 4 of the Environmental Management Act elevates the need for community participation in environmental management. So I think consulting traditional leaders alone or local leadership alone, in as much as we may believe in representative participation, I believe that consulting them alone is not sufficient, and there are cases that are ongoing that the Zela litigation unit is trying to work on to really define what is it when we mean consultation, what mode of consultation should be utilized, because in some instances you'd find that in rural areas where maybe the greater part of the population might not understand, not the greater part, but some members of the community might not, have the ability to read and write, will be given questionnaires as form of participation. So there is a case that is in the workings, that is in the pipeline, to really justify when we are saying participation, what aspects should really be considered, and when we are saying consultation of those who may be affected, what exactly are we looking at? So that's something that is on the pipeline, and I understand that the Environmental Management Act is also going through under review. So those are some of the aspects that we are advocating that they should be included. And when communities realize that they haven't been consulted adequately, there are administrative remedies that they can take. You can either appeal to the Director General of EMA for the reversal of that decision, or you can file a review, an administrative review through the administrative court in Zimbabwe. There is a case that Zela has filed previously, but also it's actually ongoing. It hasn't been concluded. I think those are my responses, Veronica.
Thank you so much, Josephine. Prof. Eri, if maybe you could also just answer that question that I posed to you.
Thank you for the question. So it's an excellent question. And to be honest, we haven't looked precisely at the question of whether or not environmental legal jurisprudence is gaining traction across the African landscape, as you call it. What I can say is that in a number of jurisdictions, there are sort of ongoing tugs of war, if you will, kind of regulatory battles between the courts and the executive side of the government in terms of, how involved courts can be in what's happening vis-a-vis Chinese investment. And what we've seen is that there's kind of a spectrum. There are those countries where there's greater independence and autonomy of the courts, and they actually are holding Chinese companies to account in addition to other foreign investors. And I think it's important not to just single out the Chinese, because certainly they're not the only polluters and violators, and they're not the only ones that are in non-compliance with local law by any measure. And then on the other side, there are those countries where the courts are more or less kind of under the heel of the executive government. And in that case, we don't see the courts really playing a role in sort of, offering up a bit of a check to potential violations that may be committed vis-a-vis local law. Now, I think what you've done is you've flagged a really important area for further research. And I think this is a question that should be examined, and in particular, sort of whether or not there are cases that do involve Chinese companies, and whether or not these cases are carving out new areas of jurisprudence that potentially will carry forward and gain momentum. And I can name, in the time that is allocated to me, just very briefly, I'll give you one example outside of the environmental law context, but I think it's a really interesting example. So there, in 2014, there was a case in South Africa called the Zhongji Development Construction Engineers versus Kamoto Copper Company. And what happened there was a Chinese company, Zhongji, entered into 2 contracts with a copper company from the DRC to conduct construction work on a mine in the DRC. Only the main agreement had an arbitration clause for arbitration in South Africa. And subsequently, the DRC company merged with another company called Komoto, which thereupon assumed the legal obligations of the former. Now, what happened was there was a conflict between Zhongji and Komoto. And basically, there was an issue as to whether or not the arbitration clause would be valid. And what the Supreme Court of Appeal of South Africa found was that, in fact, the arbitration clause in the contract was valid. And as a part of that, that case, they established the precedent of not only the severability of the arbitration clause, which is a really important dimension of the practice of international arbitration, that you can separate the arbitration clause from the rest of the contract. In the case that contract is invalidated, the arbitration clause is still valid, but also the rule of competence, which basically says that arbitration tribunals can decide their own jurisdiction over a matter. So what we see in this example, again, very briefly, is that Chinese companies, whether they like it or not, they are forming jurisprudence in local host states. In this case, jurisprudential matters involving international arbitration in South Africa. But what I'm saying is that this question should be taken forward in looking at China's presence in creating new environmental law jurisdiction in Zimbabwe and other African states. So I'll stop there. Thanks.
I think we've lost Veronica once more. But nonetheless, I think we are getting towards the end of today's session, but I wanted to give my panelists the opportunity to share their final remarks. I'm excited by the idea of identifying a potential area for future study. I think when we conceived this PEDNAC series, the issue was, one of the key objectives is how do we formulate a research agenda where we produce information which the market can consume. And I'm excited with what you flagged, Professor Eri. So I want to go back to Josephine and Professor Eri for one more time. What are your final reflections in as far as today's topic was concerned? Over to you, Josephine, and then over to you, Matthew.
Okay, thank you, Farai. My final reflections will probably be, I think there is a need for us as Zimbabwe, for us as a people, to really look at what kind of development are we looking at. what kind of investors are we looking for in order to improve our economies? Because we cannot continue sacrificing the environment for economic development. We need to create a balance. We have policies. If you look at the National Development Strategy 1, if you look at the Constitution, and even the TSP, which came before the National Development Strategy, they all have clauses that relate to sustainable development. So we need to curve out, a trajectory of sustainable development that is workable for us. And we do not want to have a situation where in 10 years, in 5 years, our environment is totally destroyed for the sake of the economy. So there's a need for us to start doing better as a country and start doing better as a people, because we cannot continue doing as we are, because the people who are suffering are the least responsible for the environment, for the environmental harm. You talk of your children, you talk of mining host communities, you talk of even women. So there's a need for us to do better. And in finding a solution, the solution, though I am a lawyer and I'm inclined to lean on the law, the solution cannot only be in law. We need to find what exactly do we need to change and how can we change that. And sometimes law alone cannot be the answer to that question. Thank you, Farai.
Thanks, Josephine. Thanks for those final remarks. Indeed, law is not the only remedy to most of our challenges. And I think it does augur well with the idea of the political economy dialogue on natural resource governance beyond legal reforms. What else can we do to shape policies around natural resource governance in Africa? So, Prof, over to you. I know the FOCAC is coming in September. And I think this marked the fourth FOCAC since its very origins in 2002, if I'm not mistaken. Are there opportunities for environmental defenders? Are there opportunities for lawyers and communities to shape the agenda at the FOCAC level, so that I think the environment is protected and there's sustainable development that respects communities' rights and development that respects environmental rights in Africa? Over to you, Professor Matthew.
Thank you, Farai. Thank you for the question. So I think there's no question that environmental lawyers and activists and other concerned members of communities have to play a role in shaping the agenda at such venues as FOCAC and others, right? I think we're at a point now where it's absolutely unmistakable that we are experiencing and heading towards environmental crisis. I mean, all of the data points directly to that concern, and unfortunately, it is the developing countries that will most likely experience hardships before the post-industrial Western countries, and they're already experiencing the hardships, right? So, the time is yesterday to act, and I think that the extent that FOCAC and other platforms can promote more awareness of sustainable development and truly implement it beyond a kind of official speak and broad political discourse, then I think that would be wonderful. But in conjunction with that, I think there has to be other venues and formats and channels, whether it's formal litigation or transnational advocacy and linkages with other concerned groups and communities, NGOs, think tanks, activists, et cetera, that can also be very helpful and supplemental to some of these more official delegations and their meetings. And so I think, I totally support what Josephine's put forward. I really like this idea of sort of developing, Zimbabwe's notion of development. It has to be for Zimbabwe, of Zimbabwe, and the legal dimension is one part of a broader story. And I think as part of this, countries may potentially look to China. There's lots of dialogue, lots of discussion about sort of China model. I'm not sure exactly what that means. I do think that lessons can be learned from China. There's no question about it. But China can be one source of inspiration amongst other sources, for example, from other African states and from the Western countries and other major developing countries, whether it's Brazil and India and elsewhere. So I'm a broad supporter of greater discussion and dialogue, and I think the social sciences and the lawyers need to do a better job as well in terms of bringing together the data and the advocacy and the for cause kind of litigation. So this is all to say that I really enjoyed this conversation. I want to thank Zella again for having me, for allowing me to speak. And I really do look forward to further conversations, and I hope we can work towards actionable programs. So thank you very much again.
So thanks indeed, and wonderful to close on that note. Colleagues, I think this is the end of today's PEDNAC series. We are planning for the fourth one, coming on the 30th of August. I think making a follow-up to the first one, I think as we prepare for the FOCAC of 2021, what are the considerations for Africa to shape the agenda in as far as Chinese investments is concerned in Africa? From us, thank you so much for devoting time and effort to it. Thank you so much, and that's the end of today's session.
That was one of the political economy dialogues on natural resource governance, PEDNAC, brought to you by the Zimbabwe Environmental Law Association, ZELA, and the Africa Institute for Environmental Law. For more information, please check out www.zela.org or follow the African Institute for Environmental Law on Twitter at AIEL_info. Stay tuned for more episodes.